welcome again, everybody. This is the last and final session for today's workshop. And we are fortunate that we have very remarkable speakers and practitioners and educationists and you name it, anything, right, in this session. And definitely, if you can see the titles that we have and whatnot, we are getting into the future when it comes to heirs property and sustainable forestry management. So I'm glad that Mr. Terence Rudolph is joining us today. As you can see, he's a state conservationist in the great state of Georgia. He looks after USDA and RCS. And I came to know Terence for some reason that I cannot recall, but I definitely know that Mr. Rudolph was part of NOAA's PhD committee, and his comments were really remarkable in terms of giving us an opportunity to look into the fact that how policymakers and administrators think about heirs property and sustainable forestry management. So, Mr. Rudolph, thanks again for serving on NOAA's committee. It was really good to have you. And I'm very thankful to you for coming together on this workshop. And we are looking forward to your talk today because I'm sure a lot of people are ready to listen to you what NRCS is planning and what are the future plans when it comes to NRCS and heirs property. So with this, time belongs to you.
Okay. All right. Thank you, Dr. Vidi, and good afternoon, everyone. So as stated, my name is Terence Rudolph, State Conservationist for NRCS here in Georgia. And it's definitely delighted to be with you. And today it's been a good day so far. And I know you've heard a lot of good information. So I hope that we can continue the trend. I know you've heard a lot of good information about heirs property and the impact of heirs property as well today, but I want to focus on how USDA is helping to secure a better future for your family, tackling the need of the land today. Next slide, please. So USDA and the 2018 Farmville Goals, seem like every Farm Bill, there's always goals in Farmville, but particularly this one is to ensure strong support for Americans, farmers and ranchers, streamline and simplify programs, because within the Farm Bill, there's so many programs, and sometimes those programs could be confusing, because there's so many, but this particular Farm Bill definitely has streamlined the process. Some we'll go over that a little bit as well. And then of course, to fulfill the Secretary's goal of improving customer service, you can always improve customer service. And then lastly, to continue to offer the type of assistance that producers have come to expect from USDA. And then of course, we want to always try to improve upon those as well. Next slide. Changes made by the 2018 Farm Bill. The 2018 Farm Bill provided framework for how we can streamline our way of doing business, as well as from working closer and more effectively with our customers by using one application for our programs, by simply working smarter with our staff and fellow USDA colleagues. As a result, we're doing a better job of working across silos, servicing our customers in new ways that is saving money and time, because at the end of the day, it's all about saving money and time, particularly when you're dealing with taxpayer funds, as these programs are all taxpayers' dollars. I would like to give kudos to my colleagues at the Farm Service Agency who are developing new tools and lending programs specifically for their heir property owners. You can find more information about this at farmers.gov. And then in the search box, make sure you type the word heirs property. Next slide, please. Next slide, Dr. Beatty.
I think there's some lag, so bear with me. So after this, this is okay?
No, the next slide.
Okay, got it. I think there's a lag here. Wait a second. Yeah. Ah, boy. So we talked about this one. Then this is the slide, Mr. Rudolph.
All right.
So you want the next one?
Yeah, I want the next one.
Okay, got it.
Yeah.
Oh boy, what is happening?
When that happened to me, I turned off the share and then I turned it back on. You can try that.
Oh, wait a second. Something is wrong from some other side. Wait a second. Wait a second. Bear with me. Now you can see.
Yes. But
Sure.
can you go back one slide?
Right. I think somebody also started sharing their screen and that messed up the program, but now we are back. Yeah.
Okay. All right. Yeah, right there.
Sorry. Yeah.
Okay. So USDA position to help in this 2018 Farm Bill is two critical categories. One is outreach and education. And you heard my good friend Cheryl talk about the work that we've done, the partnership, and we can't do what we do without direct and indirect communication and work relationship with our community-based organizations and partners such as MacArthur Seed and many others to take the USDA message further into the community who need it most. And since 2015, NRCS and partners have reported having held over 879 events, servicing over 404,316 customers. So that's been a lot of customers that has been touched since 2015, and that number is continuously growing each and every year. The two most important jobs that NRCS does is technical and financial assistance. We are a technical agency first and foremost, and we use the financial assistance to help drive the technical part of our agency. The services that we provide is free of service. We offer free consultation through what we call the conservation planning process, where we look at assessing the land and then meeting the landowner's objectives, and then of course working with the landowners on long-term goals that they have on their property. And then we also have conservation programs through the financial assistance portion, disaster assistance, and lending programs that are also available not only with NRCS, but our partner Farm Service Agency as well. But it depends on the need of the producer. Next slide, please. So I'm gonna talk a little bit about programs here. The Farm Bill makes our work possible through the host of many programs, such as Conservation Technical Assistance, the Environmental Quality Incentive Program, which is our most popular program, the Conservation Stewardship Program, which is our largest land-based program, and then of course, the Ag Conservation Easement Program, just to name a few of those programs. NRCS invests on average about $8 million every year, into conservation systems that help producers stay profitable as well as productive. In Georgia, just last year, we obligated $66 million on 246,000 acres. In recent years, about half of that has gone to historically underserved producers, socially disadvantaged, new, beginning, and veteran producers. We have offices in every county throughout the state, particularly throughout the nation as well, that is ready to serve. So NRCS is visible, and we should be ready to serve. Next slide, please. So we have what we call the 5-step assistant process that we utilize to assist landowners on their farm, ranch, and forest land. Step one is planning. When I referred to conservation planning, that's what step one is. Step two is the application process, which refers to the financial assistance that I'll talk about. Step three is eligibility. It's important that the proper paperwork is filed so that you are a eligible valid customer. Step four is the ranking process that is needed and is performed or conducted at the local level with the local work group. And of course, the final step is implementation, which is getting that work put on the ground. Next slide, please. A little bit about the planning process. NRCS conservationists will work with the producers to develop a conservation plan that address the needs of the clients, as well as identify those resource concerns out on the land. And then, of course, to make sure that federal, state, and local agency or regulatories are met for whatever we do on that particular land. Some of the support documentation that goes in the conservation plan is, of course, job sheets, engineering designs, standards and specifications, operation and maintenance of each of those structural practices that are planned. Next slide, please. And this is an example of a conservation plan. On the left-hand side would be more of the plan, and then on the right-hand side is the conservation plan map. And you really need both of those to go together because it would be hard to understand one without the other. You can read the plan, but if you don't see the map to talk about which field or which track number, then it definitely would be hard to kind of understand that. So this is an example of a conservation plan and the plan map. Next slide, please. So this too is also part of the conservation plan. You have, typically we have a soil map of your tract boundary in that. You might want to say, you might ask why soil map, because everything revolves and starts with the soil type. So if you have the appropriate soil type for what you're trying to do, then it makes the job a lot easier. And of course, the topographical map is looking at the elevation and drainage area of that particular land as well to help determine some of the natural occurrences that could occur due to heavy rain or flooding. Next slide, please. So the application process, for most of our programs, applications are continuously, which means you can sign up anytime. The only difference is that there is a ranking deadline for each sign up. So we just have to make sure that you are within the appropriate ranking timeline for whatever program that you are signing up for. And then of course, you got to make sure that you use your legal name or whatever name that you use to file with the IRS. It's important to do that. And then, of course, appointments will be made later on to do what we call an assessment of the property. Someone would need to come out with you and look at your farm, because how can you best do a conservation plan without putting your eyes on the farm? So we need to make sure that all of those are done. Next slide, please. So this form here is called an NRCS CPA 1200. It is the one-stop application form that I talked about earlier. In this form right here, the first block talk about just your name, address, and location of your property. But of course, if you look at number 1, which is critically important, it talks about, do you have farm records established with the appropriate USDA agency? And if you say no, then of course you have to make sure you go do that before you can continue with the application. 2 talks about give you an option to select which program that you will be interested in applying for. And then 3, of course, talk about if you're going to sign up as an individual or you're going to sign up as an entity. Next slide, please. The ranking process, NRCS will rank application according to local resource concerns, the amount of the conservation benefit the work will provide and the need of the applicants. One of the reasons why ranking is so important is because of the amount of funds or lack of funds thereof. Because, to give you an example, in 2020, Georgia had $100 million request in the EQIP program, but our allocation for 2020 was only right around 36 million. So you can imagine 100 million in requests, but only 36 million of funds. So you have to have some type of ranking criteria to help make sure that the top or the best applications are selected for funding. Now, the unique thing about the local work group is that that's where the resource concerns are prioritized. And what I mean by resource concern is it just depends on the location, right? So let's say in Southwest Georgia, you know, the local work group may have determined that the major resource concern in that particular area is cropland, forest land, or pasture land or wildlife land. So there's 4 land uses that I mentioned, but maybe only 2 is a priority. And so if cropland and forest land are the 2 priorities, then they would determine the percentage of funds that would need to go to each of those land use to address the resource concern there locally. Typically, the local work group is made up of local soil and water conservation district official, agriculture producers, whether they are cropland producers, forest land, pasture land, livestock producers, and any other agriculture related organization, nonprofit organization that is interested or have an interest in soil and water, they can be part of that local work group. So if you're interested in being part of the local work group, then you're more than welcome, and it's a voluntary program to be part of that. You just need to contact your local district conservationist and ask them to allow you to be part of the local work group, and you can do so. Next slide, please. So eligibility is really critical. Number one, the participant must have a farm record established with the Farm Service Agency, as I mentioned before. And you need to have a copy of your deed. If not, you need to have a lease agreement to show that you have control of that land for 2, 3, 4, however many years that you have control of it to participate in the program. And then you have to have a farm number, which is given by the Farm Service Agency, a tract number. You can use your Social Security number, or you can come up with a tax ID number that you can utilize as well. One good tool that FSA created this July 2020, past July 2020, is a fact sheet that's entitled Guidance for Heirs Property Operators Participating in FSA's Program. So if you haven't received that, make sure that you look that up, because that fact sheet will help you if you haven't participated in these programs before. And of course, we have what we call an 80-1026, which is also filed at the Farm Service Agency. And that is a highly erodible land and wetland compliance. And the reason why that is up there is because if you are wanting to participate in Farm Bill, any Farm Bill benefits, you have to make sure that you do not violate highly erodible or wetland provisions. If you do so, then you would not be eligible for any programs at that point in time. And then, of course, you have to make sure that a direct deposit form is completed at that office as well, because that's how all transactions in terms of resources are dispersed, would be through direct deposit. Next slide, please. All right, implementation. If the applicant is selected, so once you have your application has been selected for funding, then you would be given the opportunity to enter into a contract to complete the work. Once the contract is developed and it's signed by the applicant, then you will be provided all your engineering, job sheets, design, specification, or everything that's needed to complete that practice or practices in the allotted time. Now, Once that contract is signed, it is a legal and binding document at that point in time, which means that you don't want to, when I talked about earlier how 100 million in requests, but only 30-something million was granted. There's such a need out there that if you take money from someone else and you decide not to utilize those funds, then another producer were definitely affected or impacted in some way, form, or fashion, because a lot of them need the funds in order to maintain their farm operation. So that's why I mentioned that it is a legal and binding documentation. So make sure that you adhere to the work of that contract. Typically in a contract, once you approve, you have 7 months roughly to start a practice. And then once you have started, then you have about 16 months to complete it. So the office staff is pretty flexible. So in the event of any Mother Nature disaster that could occur, and if you need more time, all you have to do is just request a modification to extend your contract due to that particular hardship, and that will be granted. So keep that in mind. Next slide, please. So usually during the implementation process, when I talked about the different practices that are installed, and I have here 2 practices that can be utilized under soil erosion. As you see, no-till, which is popular, and of course, crop residue management. But these are practices that may be contracted in the contract that I mentioned about earlier. These practices here will help slow down water so that it can infiltrate down into the soil profile, because the purpose is to keep the water on the field and not allow the water to run off the field. So keeping the water on the field is better for the crops. And plus it helps control soil and water erosion. Next slide. We talk about water quality as a practice, and particularly here in Georgia, we do a lot of grazing related practices. We utilize fence to rotate the livestock and pasture to keep forage growing throughout the year. We keep them out of what we call environmentally sensitive areas, such as your creek, your ponds, and your wetlands. And then as a result, we help provide alternative water sources, such as water tanks, protected with reinforced materials to keep the soil from eroding and running off the field. You can see a couple of pictures there that shows 3-strand barbed wire fence, which is pretty popular. And of course, the water tank with heavy use area around it to solidify that area so it doesn't get contaminated. Next slide, please. So these 2 practices also improve water quality, particularly as we assist poultry growers to help them in managing their nutrients. We help them to store their litter and compost until it is ready to be applied to the land. And of course, that is according to a nutrient management plan. By keeping the litter covered and applied strategically, the nutrients become a valuable asset to the farmer versus becoming an environmental liability. So if we can help that become an asset to the landowner, we definitely don't want it to become an environmental liability. Thank you. Next slide, please. So forestry, I know you heard of forestry a lot today during the presentation. And so NRCS does a lot with forest landowners. We work with them in various stages. We can assist them with improving existing forest stand by doing what we call thinning and burning. We can help by creating what we call open areas for wildlife habitat. And of course, to just improve timber quality. Next slide, please. So as implementation continues, this is important because once the practices are completed, then the landowner typically would notify, or the contractor would notify NRCS that practice is completed. NRCS will then conduct a field visit. If the practice standards and specs are met, then those practices will be certified as completed. And then typically once they're certified, it takes about 10 business days to receive a payment. So after they complete it, then we will process the payment, and then the landlord should receive those funds in the direct deposit form that I talked about earlier. Next slide, please. Now, financial assistance, I put this up there because typically any assistance that we provide through, particularly our most popular program, the Environmental Quality Incentive Program, is at the rate of 75% of the cost, not to exceed 90% associated with whatever engineering plans or designs or material equipment, installation, labor, management, maintenance, or any training costs. However, 90% is offered as a regular assistance to all historical underserved producers. So all historically underserved producers will be eligible for 90% of the cost. Next slide, please. And historically underserved farmers and ranchers, as you know, in the 2018 Farm Bill, it included provisions that address the unique circumstances and concerns of social disadvantage, beginning farmers, limited resource farmers, and veteran farmers and ranchers. The Farm Bill program also provided voluntary participation, because one thing to keep in mind is that any of these programs that I'm talking about today are all 100% voluntary, and they do offer incentives, and I mentioned those in terms of the 75%. And if you fall in one of these special categories, then you definitely qualify for 90% or up to 90% of the cost. The Farm Bill also focused on equity and assessing the USDA Department of Agriculture programs and services across the board. All right, next slide, please. So limited resource farmers and ranchers. I put this up there because, you know, sometimes there's always, when you think of limited resource farmers and ranchers, you know, just to give you a definition, with direct and indirect gross sales, not more than the current index value in each of the previous 2 years. Another definition is that is who has a household income at or below the national poverty level for a farm of 4, or less than 50% of the county median household income in each of the previous 2 years. You also can use what they call a self-determination tool that has been made available to the public, and you can complete that online, or you can print and complete it hard copy. That tool is at the website there, which is limitedresourcefarmer2.sc.egov.usda.gov. So typically, when you go down to the FSA office, and if you know, they would help you determine if you fall under the limited resource farmer beginning category. They won't answer the question for you, but they'll go over the definition, and then you would have to make that determination at that point in time. Next slide, please.
Mr. Rolfe, we have like 2 minutes to finish.
Okay, all right. Beginning farmer and rancher is another one. This is just a quick definition. If you've been farming for less than 10 years, then you qualify as a beginning farmer. Next slide, please. Social disadvantaged farmer and rancher. That is if you fall under one of the special category where you have been subject to racial or ethnic prejudice because of your identity as a member of a group without regards to individual qualities. And that group would be American Indian, Alaska Native, Asian, Blacks or African American, Native Hawaiian or other Pacific Islanders and or Hispanics. And then the next one is veteran farmer and rancher. I mean, it is what it is. I mean, if you served in the military or armed forces, then you qualify as long as you haven't been dishonorably discharged, and as long as you've been farming for less than 10 years, then you also qualify for that benefit as well. And then, of course, next slide, there's a whole gamut of online resources: USDA.gov, farmers.gov, newfarmers.usda.gov, nrcs.usda.gov. Please visit those websites. Or if you just happen to be in the office, please contact your local county office for any assistance. If you can't get any assistance there, then please contact my office at the address above, 706-546-2272. And then we'll be glad to assist you in the way that we can. With that, Dr. B, that would be the end of my presentation. And of course, all of our services are non-discriminatory. So thank you.
Okay, great. So I think in the interest of time, we can take 2 questions because we have to start our next panel, which is in time. So let me see where are the questions and what type of questions are those. So there is some questions. Let me start from the top. So the first question is, my question was that minimum acreage was focused more on the minimum amount to purchase that has been modeled to result in profitability as opposed to qualifying for NRCS and Forest Service programs. So boy, I think C.W. Lewis, if you can give a little bit more information, that will be helpful because question is not very clear until Mr. Rudolph can understand it. And if he clicks on Q&A, he should be able to see the questions. And Steve, I think your question has already been answered in terms of veterans benefit, right?
Yeah, I guess to answer that question, Dr. Davidi, there is no, there's no minimum acreage for the most powerful, popular programs. But you need to have at least to be safe. I mean, you want to have something, 1 acre, 5 acres. You need to have something that would show that you are a valid customer. So the key is valid customer.
Right. And Mr. Rudolph, would you like to answer the question asked by Aaron on carbon credits and carbon from farming?
Yes, I mean, that's something that we're going to start getting into in this new administration. So far, utilizing the EQUIP program, we haven't been doing a lot with carbon sequestration, but I know that it is in the forefront in this new administration. So we will be doing more on carbon sequestration as time move forward.
Okay, yeah, everybody's looking for this administration, especially what they're planning to do for carbon and climate change. So I think everybody's waiting for more guidance on those lines. So with this, right. Mr. Rudolph, I think we have to stop here, but thank you so much again for all the time and interesting insights from federal government. And I'm glad that you mentioned about that document that FSA just created, heirs property.
Right.
So that will be interesting because I have not seen it. I will definitely check it out. And I also request all the attendees to go through that document. I think that document has a lot of answers that we are looking for as a group here. So thanks again for your time. Right.
All right. Thank you. Appreciate it.
Sure. So next speaker is, I'm pretty sure everybody knows about him. And he is also moderating the panel, which is going to basically discuss what future looks like when it comes to heirs property and sustainable forest management in South and in this country. And the moderator is Professor Thomas Mitchell. As you can see here, he's a professor of law at Texas A&M University, and he is our recent MacArthur Fellow. So again, Professor Mitchell, congratulations so much, because getting that fellowship is not simple, and I think you totally deserve it. There is no question mark there. right? So I think the plan is that Professor Mitchell will talk about first, and then he will also introduce his panel members. So for next 1 hour, 10 minutes or so, time belongs to you, Professor Mitchell, and thanks again for all the time and all the interesting insights that you keep bringing to us all the time. Oh, it should be here. Professor Mitchell, you are muted if you have already started speaking.
Yeah, I'm sorry, my bad. Are you,
That's
are
okay.
you good?
Yeah, we are good now. Yeah.
Okay, so listen, let me just first of all thank the Warnell School and Puneet and staff and any other faculty who made this really incredible conference on heirs property happen. I know they've been planning it for months. I also, when I kind of look at the range of people participating today, whether they're panelists or they're participants, I kind of think of the group in the aggregate as kind of my people, whether they're academics, government officials, folks from various nonprofits, individual landowners, and maybe even businesses interested in helping heirs property owners. And then just kind of as a general comment, I just want to give some context that when I started this kind of work about 25 years ago, you know, certainly it was the trends in African-American property ownership in the South were bad. It's not like they've gotten great. But you know, I think that if we're not living necessarily in the golden age of African-American land ownership, this is the golden age, I think, of African-American or heirs property work more generally. 25 years ago, hardly any academics, certainly almost none in law, gave this any interest. There was very little happening on the law and policy front, and there was scant media coverage. And it's really been quite remarkable to see the level of interest in this issue across the many different types of stakeholders really kind of blossomed in the last few years. All right, so then let me just, I'm sorry, go back here. Oops. Oh. I'm sorry. I'm trying to go to the title page and it's.
Yeah, use those one. That is my.
Right. All right, so I just wanted, obviously Puneet's introduced me. I'm really have the good fortune of being joined on the panel today with just some excellent people, many of whom right? So you see the list here, right? And and you see their various affiliations. And so I very much look forward to seeing presentations as well. Okay, and I do have to, I remember somebody earlier, so I have to kind of, I think Skipper gave the caveat that I'm not providing legal advice. This is for educational purposes today. I have to provide one further caveat. I am a law professor. I have one license in California that I keep inactive. So I don't have the ability to provide legal advice to any individuals or families. And I just don't have the bandwidth because I have my full-time job as a law professor, but probably the work that I'm most known for, my law and policy work, is really a second full-time uncompensated job on top of my full-time job. And I do have a family. So I've gotten, in the last few years, hundreds of emails from families. I think I'm a practicing attorney, or maybe I have a legal aid organization. I don't. And unfortunately, I can't address those types of communications, unfortunately. All right, so we've heard a lot about kind of heirs property ownership. We know that just in terms of the formal legal name for this type of ownership, it's properly thought of as a subset of tenancy and common ownership, which is the most prevalent form of what we call common real property ownership in the United States, where the ownership is undivided, right? Where individual members have a fractional interest in the whole, but don't own any specific part of the property. As we heard from Skipper, that heirs property often, but not exclusively, as she really correctly makes the point, results from families who don't make wills or estate plans and then have their property passed by intestate succession. And then third, as we've heard, at least implicitly, the rules governing this form of ownership are often incredibly counterintuitive for those who own such properties, which leads to a series of misunderstandings or myths about people's rights vis-a-vis the property or the security and stability of the property. And pretty much what might be rational or intuitive turns out that it's pretty much the opposite of what the law is. So a couple of things I've been proselytizing on in the last couple of years is as COVID-19 has revealed, we have a number of pre-existing racial gaps in this country, obviously in the healthcare system, in the criminal justice system, in the educational system. Little known racial gap that's little appreciated is the racial will-making or estate planning gap. So this slide here just shows you, based on one study by 3 economists, and there's no national study on estate planning or will-making, and that's for methodological reasons. It'd be nearly impossible. So I'm not saying this is the definitive study, but it's one that I've utilized. So it shows here that there's a 40% gap between white families and black families making wills, about 64% to about 24%. Not surprisingly, in every racial or ethnic group, those with the highest education make wills at the highest rate. But if you can see, for African Americans, that group is African Americans with at least a college degree, sometimes a college degree and a graduate degree or a professional degree, including a law degree. And though highest for African Americans, that rate is only 32%. And you can contrast that, at least in this study, with the group among white Americans who have the lowest will-making rate, and that's white Americans without a high school degree. But still, that group in this study had a 57% rate of making wills. All right, so just generally some of the things about heirs property ownership challenges. So one is this fact that the ownership tends to be unstable and insecure significantly because of this rule of partition, but not only. And so we've talked about that before, and this is one of the things that's counterintuitive for a lot of families. A lot of families think that the more heirs they have, the more secure their property is, and that's based upon a wrong assumption that if the property is going to be sold, it needs the consent of everybody or maybe a supermajority. The rule of partition is just the opposite. Any one of the common owners, fractional interest owners, can go to court, file a partition action, and petition the court to order the remedy of the court-ordered forced sale, often called the partition sale. So with heirs property, it's the reverse. The more heirs there are, or the more tenants in common there are, by definition, mathematically, the more insecure the property is. So that's one form, and then we'll talk about some of my work in this area addressing that. The second problem, and this is not necessarily a comprehensive list, so I've kind of ticked off 4 major ones, is that the ownership often becomes contentious or gridlock. That is significantly attributable to that if you don't make a will, the form of the tenancy in common you get is pretty much the worst form of common real property ownership that is known in the United States. It's not stable, and under the form that the state gives you, it doesn't properly allocate rights and responsibilities, which then predictably will lead to a lot of disputes, including maintaining property taxes and other what we call carrying charges. There's also this problem that I think of heirs property ownership today as being a present manifestation of Jim Crow. I say that because when African American families first became kind of property owners after emancipation and the end of the Civil War, as I think Connor Bailey indicated earlier, is that for all practical purposes, that first generation of African Americans lacked any access to lawyers. There were hardly any black lawyers in the country at this time, and most white lawyers in these rural areas didn't want to take on black clients. And so I think what initially was a bar due to Jim Crow Unfortunately, in many families, that as generations went by from one generation to the other, it became kind of normal not to have a will. And I know that because I've talked to a lot of African-American attorneys who then, when I've presented, have kind of admitted that they didn't have a will, right? And so, but what's happened in the last few years, at least, is that I think because of this great work, sometimes of government departments, agency service, or these wonderful nonprofits, I think, and maybe media coverage, I think for many families, they're realizing now that the heirs property or tenancy in common under the rules the state will give you if you don't make a will is this horrible form of ownership. And they've learned that you can change the form of ownership. Unfortunately, many of these families have now discovered that theoretically you can change the ownership of the property. And we've heard from Mavis and others about other options, the LLC, trust, something called a tenancy in common agreement. But unfortunately, in every state in this country and the District of Columbia, to change your form of ownership, you need to get 100% agreement among the various co-owners, which makes it practically impossible in a number of situations to change that form of ownership. Okay, we've already talked about the problem of clear title, basically preventing people from getting commercial loans where they would use the property as collateral and participating in a variety of governmental programs, whether at the local, county, state, or federal level, and not just in USDA and in other federal agencies or departments or services. And then one issue that is sometimes not as well appreciated, and one of the people I know here at Texas, at University of Texas, is Heather Way, law school there, is kind of highlighted how on things like homestead exemptions, how heirs property owners, especially those who are owner occupiers of the property, really have a lot of difficulty qualifying for those types of property laws that are intended to benefit like homeowners and property owners. So let me just talk a little bit about the kind of Uniform Partition of Heirs Property Act, and what I'll talk about is the Hierarchy of Remedies. As many of you know, I served as the principal drafter of the UPHPA. It has a lot of bells and whistles, but I think, as a previous panelist mentioned, I think of it as having three big pillars. So pillar one is the buyout provision, or the right of first refusal. So that's if any one of the common owners goes to court, files his partition action, and specifically requests the forced sale remedy, the other common owners then have the right to buy out the fractional interest of the co-tenant who sought the forced sale, right? So sometimes people have referred to this as the Shark Repellent, because any predatory speculator or developer, that's the last thing they want. And as a result, many of them will likely not file these legal actions in the first instance. The second is, and I think that John Shellhouse and maybe Sarah referenced this, is theoretically, there are two big remedies in a partition action, although that's not exclusive, but one is the physical division of the property and the allocation of the various tracts that would come out of that to various ones of the tenants in common, or the forced sale with a distribution of the sale proceeds to the individual fractional interest owners based upon their percentage ownership. The overwhelming number of states in their state statutes say that the physical division is the preferred remedy, because that's seen as being much more consistent with maintaining important property rights, because a forced sale is a pretty radical thing for the law to do. But over time, state court judges came up with a test to decide whether the forced sale could be justified. And as a result of these state statutes not really being written in sufficient detail, this test that the state courts came up with basically reversed the presumption, at least for disadvantaged families, and made the forced sale the preferred remedy. So what we do in the second provision is say, no, we're serious that the physical division is the preferred remedy, and we are going to provide substance to that in the way these state statutes hadn't, by coming up with this multi-factor test that consists of some economic considerations, including the one that the courts have been considering about whether or not the property has what you call economies of scale. And we say, okay, that's proper. But then there's also a series of non-economic considerations. Has there been longstanding ownership in a family? Does the property have some separate cultural or historical significance? Would selling the property result in substantial harm to somebody who's a co-tenant, an heir, who's using the property for some lawful purpose, whether commercial or residential, and that selling the property would result in substantial harm? In the case of residential, severely reducing their quality of housing, maybe even rendering them homeless. And the third part recognizes that in a subset of these partition cases, the forced sale would be the appropriate remedy. Heirs property is not limited to farmland of substantial acres. Heirs property could be in a single family home in New York, LA, Detroit, Chicago, Atlanta. And you're not going to be able to, in most cases, divide a single family home. So the selling the property in that context would be the remedy if there's been a partition action filed. What we do is we totally restructure the sales procedure, because the sales procedure, the pre-existing partition law mandated, usually results in a sale well below market value, and often a fire sale where the family will get pennies on the dollar. So we basically say, instead of these auctions at the courthouse on a specific date, often 2 weeks after the court has ordered the sale, with no ability to inspect the property, no ability to get financing if you want to make a bid at the auction. In most states, you got to pay in cash at the conclusion of the auction. What we say is that, no, the court should appoint a real estate broker who lists the property for its appraised fair market value, uses all commercially reasonable practices to sell the property, and then bids can be contingent on getting financing. And so, just as a basic matter of real estate economics, this new sales procedure, which we call the open market sale, is going to yield a substantially higher price. In a case in Texas here, when they use this, the property sold for $2.5 million, and all of the lawyers in that case acknowledged that if they had used the auction sale, the sheriff sale, the property would have sold for no more than $2 million. I mean, no more than $1 million. Okay, so just so where are we now? I kind of give you a smattering of some of the states where the UPHPA has been enacted into law. As you can see, it's in every region of the country. We have it from Hawaii to Florida, from Connecticut to New Mexico, 3 Midwestern states. And so there's been a variety of different, let me just kind of pull up the map a sec. Okay, so here's where we are. If this is going to come up in just a second here, a little slowly. So one of the things that just shocks people is when I started this work, like I said, almost 25 years ago, the consensus opinion was that this was a law that simply could not be changed. And then folks had a kind of some people hinged and said, well, you might get 1 or 2 states, but certainly no state in the South. And that's, was kind of based upon experience where for 30 years, starting in the 70s, almost every attempt in the southern states to reform this area law failed, with a few discrete exceptions, but certainly nothing as comprehensive as the UPHPA. So you see here that we now have 8 of the southern states, and we already have introductions in 4 states. It's in the blue at the top, and we're expecting introductions in at least 3 other places: California, Oregon, and the District of Columbia. All right, so let me just also kind of give you a picture of the waterfront. So we've gone from something where, there were low expectations, to put it mildly. We're going to have these states, and then there's some other states that might be in the mix in 2022, including a couple of southern states. But what we've had is, not only have we had this number of successes, but we started to have an expansion. The act we got enacted into law in New York and Virginia in 2019 and 2020 respectively, actually have a broader scope than what I call the standard UPHPA, because there was interest in expanding it. We've had some real success after the 2018 Farm Bill became law. As some other folks maybe mentioned earlier, there's some provision in the Farm Bill that provides incentives to states that have not enacted the UPHPA to do so, because farmers and ranchers who owns heirs property in those states will have a greater access to a range of programs and benefits in the USDA, at least theoretically, than similarly situated heirs property owners in other states. And as a direct result of those provisions in the Farm Bill, we've gotten Illinois, Florida, Mississippi, and Virginia in the last couple of years, states that were beyond our control, beyond our reach, including Mississippi, where we had failed twice before the UPHPA became law. And with the Farm Bill, and I saw one of the participants was Frank Taylor from Mississippi. We made that happen. I see Ebony and Nancy Hyde, Ebony Alexander, and they helped make that happen in Virginia. As a result of this success of the UPHPA, the organization that promulgated the UPHPA is called the Uniform Law Commission, approached me about 2 years ago, and they said, hey, do you have any ideas for a second Uniform Act? And I said, well, actually I do. And one earlier when I talked about that gridlocked ownership, where you need 100% agreement among the co-tenants to change the form of ownership, the Uniform Law Commission looks like it's going to set up a drafting committee to re-examine that. And going back to when we talked about an Indian country, I remember Jim referenced something similar when he talked about rules governing percentage of the common owners who would have to come to agreement about leases and otherwise. And then we've had the pretty much the most robust bill ever addressing the status of Black farmers, is the Justice for Black Farmers Act, introduced by Cory Booker, Kirsten Gillibrand, and Elizabeth Warren. This built upon some of the 2018 Farm Bill provisions, including by having the authorization for the relending program increased fivefold through 2023. Now it's a bill, right? It hasn't been voted on, but that, you know, it's kind of a hopeful development. So with that, let me turn this over to Emma Scott. Each of the panelists are going to spend somewhere between 10 and 14 minutes, and then we should have a healthy amount of time for Q&A at the end.
All right, thank you so much, Thomas. So my name is Emma Scott. I'm a clinical instructor with the Food Law and Policy Clinic of Harvard Law School. Next slide, please.
Okay, I was going to ask you if you wanted me to stop the sharing, but okay.
This works. So we are a clinic at a law school. We provide legal and policy advice to nonprofits, government agencies, and other organizations on a range of food policy questions. We also work in partnership with other organizations to advocate for policy change. And while we're doing all of that, we're educating law students about the role of law and policy in the food system. So through my work with FLPC, we're a part of the Delta Directions Consortium, which is an interdisciplinary network of organizations and individuals that works to create positive social change in the Mississippi Delta region. And it's through Delta Directions that I became acquainted with the Southern Rural Development Center, which is facilitating a collaborative group that's focused on heirs property, which is how I became much more connected to this work. So next slide. So apologies, but today was a class day for me, and so I wasn't able to attend some of the other presentations earlier in the day. So some of this I realize is going to be repetitive, but I also think it bears some repeating to just sort of level set, because I know my co-panelists will be talking about some of these provisions and what's happening now and what's going to happen in the future. So I think it's important for us to have a pretty clear understanding of where we currently are. So the Agriculture Improvement Act of 2018, or the 2018 Farm Bill, was signed into law in December of 2018. And it included provisions from the Fair Access for Farmers and Ranchers Act, which was introduced by Senators Tim Scott and Doug Jones in the Senate, and Representative Marcia Fudge in the House. And this was the culmination of advocacy that was really led by groups like the Rural Coalition, Federation of Southern Cooperatives, and Land Loss Prevention Project, and had the sign-on of, I think, over 120 other organizations. And it really contains the provisions that you saw end up in the Farm Bill. It also represented, as Thomas was just describing, a real coordinated effort with the Uniform Laws Commission to think about how to sort of leverage the Uniform Partition of Heirs Property Act and use it to kind of complement federal policy in this space. As many of you are probably aware, property law is mostly an issue for state law, and so it is kind of challenging to tackle heirs property through federal policy and the Farm Bill in particular. So I think it represented a really creative way of providing incentives within USDA programs and the Farm Bill itself to really impact state law in a way that's permissible and politically feasible. So the first section, oh, sorry, could you go back? Thank you. The first section, just to cover them briefly, for the revised documentation requirements. So this is specific, and it was talked about a little bit in the last presentation, for acquiring a farm number from the Farm Service Agency. And this provides for alternative documentation for operators on heirs property who can't provide the owner verification or lease agreement that would normally be required. So in states that have enacted the UPHPA, an operator can provide a court order verifying that the land meets the definition of heirs property, or a certification from the local recorder that at least one heir has initiated a procedure to retitle the land. In other states, there's a list of other documents that are available. I won't go into all of them here, but there are 5 or 6 other forms of documentation that are considered acceptable under these new provisions. So this was a really positive change with respect to accessing farm numbers. It, as I'm sure many have noted today, this was a big barrier preventing access to USDA programs like lending, conservation programs, and disaster relief. And we have seen, even though publicity was a little bit slow, we now have a website which Terrence Rudolph linked in his presentation with a fact sheet that that lists all of the types of documentation and how heirs property operators can access these programs now. What isn't totally clear is how well it's being implemented on the ground and how folks are being educated of their options with respect to this program. And so I know that that's something that Aloris is going to talk about in a little bit more detail during her presentation. The next program is the relending program, which Thomas just mentioned, being specifically called out in the Justice for Black Farmers Act. And through this program, USDA makes loans to eligible entities to serve as intermediaries to relend funds to assist heirs with resolving ownership and succession on farmland. There's a preference for entities with over 10 years of experience serving socially disadvantaged farmers and ranchers, and are in states that have adopted the UPHPA. So this was another incentive that was built into the Farm Bill. This piece has not been fully implemented yet. The Farm Bill did not include a timeline per se, but Congress did require a report describing the operation and outcomes of the program and recommendations on how to strengthen it within a year of the Farm Bill's enactment, which I think did indicate a congressional intent to move forward with the program pretty quickly. And we've also seen appropriations for the program in several appropriations bills, even though the program hasn't really moved forward yet. So we're still waiting on regulations from USDA to be published in the Federal Register to implement this program, and that's sort of the status where it is right now. This last piece I won't talk about too much because I know Lorette is going to focus on it in particular during her presentation. But the Farm Bill directed USDA to submit a publicly available report on barriers to beginning farmers and ranchers and socially disadvantaged farmers and ranchers to acquiring or accessing farmland, as well as the role of federal programs in improving access and the kinds of reforms that would be necessary to improve that as well. That report was due within 1 year, and I do not believe that report has been published, but feel free to correct me if you think you know where it lives. The second piece of this provision directs USDA to collect data and analysis on farmland ownership, tenure, transition, and entry of beginning farmers and ranchers and socially disadvantaged farmers and ranchers. And this is something I know Lorette is going to talk more about. Next slide, please. Thomas, I can't hear you.
I'm sorry, just let me say one thing on the second one. When we talk about resolving ownership and succession, like in layman's terms, we're talking about if the property lacks clear title, clearing the title, and that could be by forming an LLC or a trust, and then succession issues. There's a requirement that if folks are going to benefit from this, they have to make a will or estate plan if they don't have one.
Right.
Okay.
Thank you. So the next Farm Bill, I saw a question in the chat earlier about how frequently the Farm Bill is revisited. It's about every 5 years or so, and the next one is anticipated in 2023, although I've heard some rumors about pushing it up a little bit, but I don't know if that's actually going to happen. But thinking about the path forward, we're still kind of in a wait and see position, at least at the federal level, for seeing really how the more recent policy changes in the last Farm Bill are being implemented. So while we're waiting and seeing, we are brainstorming some ideas for what might be next, particularly at the federal level. And so I'm just going to mention a few of those ideas, but with the big caveat that these are just ideas at this stage. And so I don't want this to be read as a solidified policy agenda by any means. And I also just want to mention that even though I'm talking about these ideas, I did not originate them, and their content is really informed by advocates and organizations who have been working in this space for a very long time, including my friends here on the panel today. So the first thing I'll mention is a National Heirs Property or Land Loss Prevention Coordinator. There was a position of a National Beginning Farmer and Rancher Coordinator established in the 2018 Farm Bill, and that position actually advises the Secretary of Agriculture and coordinates activities between the department on different programs, policies, and issues related to beginning farmers and ranchers. The position can originate new outreach efforts and coordinate between the different agencies and departments on how they're serving beginning farmers and ranchers. And so I think a corollary position for the purpose of addressing heirs property could be really beneficial. So in particular, this position could work across agencies and departments to ensure that USDA programs are accessible to owners and operators on heirs property, and help programs develop appropriate eligibility criteria for including heirs property in their programs. I think the position could also work across agencies to focus resources on supporting the infrastructure development in regions with higher concentration of heirs property. For instance, the Agricultural Marketing Service oversees grant programs that help support the development and expansion of local and regional agricultural markets. So this could be an area where AMS tries to prioritize grant opportunities in regions that have higher concentrations of heirs property. The second thing on this list, the heirs property strike force, I could see it working with the national coordinator in an advisory capacity or function as a substitute for the coordinator position, but it would essentially include USDA representatives of relevant programs, researchers, and non-governmental organizations and advocates who focus on heirs property. And it would provide some of the coordinating activities that I described above, but could also help evaluate implementation and recommend improvements to programs. The next piece, the waivers and appropriate documentation requirements across federal programs and funding. Thomas, I liked how you mentioned that it's not only USDA programs that we're talking about. And so I think that this should be a focus moving forward now that we've seen the documentation requirement change for FSA farm numbers, looking at other places where there are sticking points for owners and operators on heirs property to access programs where maybe they need more than just a farm number, or there are other challenges that arise because of the properties that they're working with. And then coming up with, through the coordinator or the strike force, really appropriate criteria for accessing those programs for those operators and owners in that situation. The update to the relending program, I understand that the program's current structure has some historical precedent and also is structured in a way to really ensure that the lending that is going to owners is going to those who plan to continue operating on the land. That being said, I've also heard concern about the program requiring heirs property owners to take on debt, and that being a challenge as well. So I think it's worth exploring whether a case could be made for operating the program as a forgivable loan program. I think we saw a precedent for this just in the past year with the Paycheck Protection Program, which if you aren't familiar with it, it provided loans to small businesses that could be forgiven as long as a certain amount of the loans were used for payroll expenses. So we could explore the possibility of some of these loans being forgiven on, once certain conditions are met, such as agriculture being kept in, or the land being kept in agricultural use. Yes, Thomas, I saw your finger go up.
1 minute. 1 minute.
Great, perfect. And then the last piece is new grants for heirs property through the Legal Services Corporation. So this would be less of a farm bill and a USDA focused solution, but an idea of providing additional funding to the Legal Services Corporation to award grants to organizations for the purpose of expanding their capacity to provide land transition, title clearing services, other legal services that are needed by heirs property owners in particular. This could be potentially achievable through an appropriations bill. A grant program that currently exists was actually established through an appropriations bill back in 2014. But there may also need to be some changes to the regulations to help permit recipient organizations to not consider property value when deciding whether or not an owner is eligible for their services. So I think I wrapped that up in time. That's my email address if you would like to reach out to me, and I will be happy to answer questions at the end along with my other panelists.
Great, thank you so much. Loris, are you here?
I am here, yes.
So about 14 minutes.
All right. Good afternoon. So I am Laura Spate, and I am the Executive Director at the Socially Disadvantaged Farmers and Ranchers Policy Research Center located at Alcorn State University. Now, prior to becoming the Executive Director there, I actually retired from USDA NRCS as a Senior Executive Service Member. So the Policy Center then was created from the 2014 Farm Bill. It was authorized in the Farm Bill. And the only stipulation was that it had to be located at an 1890 university. So Alcorn State University was the successful grantee. And, but I want to emphasize, though, it is a national center with a strategic focus in the 18 states with 1890 land-grant universities. And it is staffed by 4 full-time employees. So in addition to myself, there is a program assistant, there is a policy analyst, and a research analyst. The majority of the work, though, gets done through contracts and subawards. And it was created, the Policy Center was created to be a voice, if you will, for socially disadvantaged farmers and ranchers, and to ensure that there was data-driven information that was available then, and not just anecdotal information. So when we went to the Agricultural Committee, there was actually quantitative and qualitative data available. For the Policy Center, we have 6 priority research areas. The impact of current agricultural policy on socially disadvantaged farmers and ranchers, land loss among African-American farmers there, and this is where heirs property lies in that priority. The participation of socially disadvantaged farmers and ranchers in USDA programs. So that is those things that either support participation or hinder participation. Priority area 4 is use of and access to technology. 2 additional priority areas were added, and that was youth programs in the pipeline, and then community and urban agriculture. Okay, so what I want to touch on then is the ongoing research studies that we are funding currently at the Policy Center related specifically to heirs property. So the first one is a study that is being conducted by Tuskegee University, and they are looking at, if you will, data to better quantify the number of acres of heirs property and they're specifically looking at Alabama and Mississippi. And prior to quantifying it, if you will, we have to make sure that we know what heirs property is, if you will, how it is classified. And what we have found, or what they have found, is that depending on the county or the state, heirs property is identified different ways. And so they're looking at, if you will, the nomenclature or to ways to come up with a consistent nomenclature. Because if we're going to measure it, we have to know first what is classified as heirs property. The second research study then, and Connor, Dr. Bailey mentioned this morning, is being conducted by Auburn University, and it is quantifying heirs property across the Deep South, and it is a geospatial approach. And so they are using core logic, if you will, to document and map the extent and value of heirs property at the county level. And they're looking at 6 states: Alabama, Florida, Georgia, Louisiana, Mississippi, and South Carolina. And then the idea is to actually analyze the data further at the sub-county level to detect possible links between heirs property, demographic profiles, and quality of life variables. The third research study then is being conducted by Lichen, or Likelihood Exchange Network, Knowledge Exchange Network. And they are looking at examining the efficacy of the Uniform Partition of Heirs Property Act in Georgia, in Alabama, and Kentucky. So the act has passed both in Georgia and Alabama, but it has not passed in Kentucky. And so they're looking at then, in essence, has it made a difference? So if they look at then partition sales before and after then the passage of the act in both Georgia and Atlanta, and comparing them to those partition sales, if you will, after the act passed, versus looking at a state again where it has not passed. The fourth research study then is being conducted by the Federation of Southern Cooperatives. And this study then is really closing the equity and inclusion gap. And so the Federation is looking at the implementation, if you will, of those things in the 2018 Farm Bill then, and how effectively, if you will, they have been and fully implemented there. So looking at the status of each of those items that were put in there, and did we go far enough, if you will? So when we made recommendations and they ended up in the Farm Bill, was it far enough? All right, and I share those then. So those are the ongoing research, studies. Now we had also completed 2 studies related to heirs property, and one was the trends among socially disadvantaged farmers and ranchers in the Black Belt region and the impact of heirs property on farming success. Now those 2 that were completed were done prior to the 2018 Farm Bill, and they were used to inform the recommendations. The existing studies then will be used to inform recommendations for the 2023 Farm Bill, as Emma mentioned there. So my contact information is on the screen. I can, if you don't remember it, if you go to Alcorn State University website, there is a link to the Policy Center and my contact information is there. All right, thank you.
Okay, great job, Dolores. Great job, Dolores, and great job as well. So our final panelist is going to be, Laurette Pigano, who's the Executive Director of the Rural Coalition, as I know many of you know. So Laurette.
Hi, it's Laurette, and I'm just trying to make sure that I'm just learning right now. I think Puneet, you're putting mine up. Thanks so much. Okay, so let's start walking through. I'm with the Rural Coalition, and I actually have a more.
Should I share?
Thomas, I do.
Should I share?
Let me see. Yeah, well, just a minute. Let me try and share my own screen because I've updated the slides a little bit to include some information. I'm trying to do it, but if I can't, then let me. I'm not sure I know how to do this. Yeah, Puneet, could you go ahead and share that one?
Oh, sure, no problems. Here you go.
Okay, there we go.
I have more colors than Thomas.
Yeah, I've never done it before. Okay, so I'm Laurette from the Rural Coalition, and we'll show this one again at the end with contact information. So let's go. I'm going to go through a couple issues really quickly. Let's go to the next one. Okay, so on this farmland ownership and data collection, and I've also put the references in here, and I'll share these slides, the legal references. Basically, what we're trying to do now, and we've collaborated with National Young Farmers on this particular section, is to do one of the total land surveys. It's a study of property owners rather than operators that's done by National Ag Statistics Service. And basically, it's to collect information on absentee ownership and also land held in undivided interest, because there are really not any very good databases about how much heirs property there really is. And we can put together little bits of information. But one of the reasons we're especially concerned about that is, as the US Treasury, as they consider programs, which right now USDA has the authority to use to pay farmers for ecological services, one danger, carbon, that's kind of setting the stage for carbon markets, and it could be very good for farmers. There's some interest in equity provisions. On the other hand, it can also cause venture capital to move to an even greater extent into farm and especially forest land. And so, basically this would be a study, and it would be also included by race, gender, and ethnicity down to the county level. Now, if at the county level you would, make somebody's land ownership be known, they would mask that data. It has not yet been funded. It was authorized at $3 million a year. And the Black Farmer Justice Act, which was reintroduced today by Senator Booker, would include an increased amount for that study. So we believe getting that study funded and underway is really, really important. Let's go to the next slide. Let's see if you're able to move it to that one, Puneet.
Skip this one.
No, this is fine. Okay, so why is this so essential? Well, right now there is a USDA climate transition memo that's been put out, and basically it kind of does what people are talking about, and I'll stick that in the chat box. But basically to pay farmers out of the CCC for carbon credit. I mean, basically for ecological services. And what we're really worried about is that once this is done, then suddenly, right now you can't necessarily make money from a lot of farmland, but if you start saying you're going to get a regular payment for, sequestering carbon, and they end up setting more prices, not only are the farmers that are already here going to be interested, but many other investors will now be able to make money from the land. And so we really think we need research and data because it could be a danger. Then the other thing is that all of these things, what we also know is in the Farm Service Agency programs, there are different eligibility requirements, and we're going to have to look through each one of the FSA programs to see if we need to do any additional things in the Farm Bill. But having data about how extensive heirs property is will help us. And then, finally, I keep on raising these questions. And then remember, when land values go up, access to credit then becomes also more difficult. And, what also happens if you increase the level of absentee owners, what happens to the welfare of rural communities? So let's go on to the next one. And we also wanted to talk here about next steps. So, first of all, we want to be moving to get this farmland ownership data collection study funded. We also need to do more work, and I think my colleagues have also talked about this, is get the heirs property relending program implemented, which means getting it out. This is the first time that there's ever been authority under Farm Service Agency credit programs to lend. It's a relending program, lend to cooperatives and other entities that can operate as a community development finance institution. So they're able to relend to multiple family members. So groups like all the ones you've heard today, and also groups like the Federation of Southern Cooperatives could do that. And then we also believe it's going to be important that the uniform partition law be used more, and by upping the amount of families that we can get financial funding to make relending packages, the more we're going to be able to show that there's a need for these programs to continue. And then of course we're all interested in how do we get more funds for legal services. And then, then we're going to be working on more ideas for the 2023 Farm Bill. And as the current Farm Bill expires September 30th, 2023. So hopefully it'll be renewed by then. And then I've also tried to cover a couple of things. And if you go to the next slide, that have come up today that I wanted to make sure that we looked at. The heirs property provision on alternate documentation is in effect, and USDA within probably the past week or two has put out this heirs property information sheet. But at the end of this, I did put in some slides with the exact references to the FSA handbook. And if you are especially working with farmers, you want to know where you can find this. But it's basically to start using it. And again, it helps probably mostly with conservation programs right now, but we hope to expand its use. And then the other thing is to be sure you get a farm and tract number, because if you go in to USDA and ask for a farm and tract number and they tell you for some reason you're ineligible or you can't get that, that means you should immediately be checking with a lawyer to see what are the encumbrances on your property or what is keeping you from getting that tract number, and then to resolve those issues. Some questions were also raised about minimum acreage and payments, and those exist in a few programs, but there is a waiver in some of the Farm Service Agency programs. And in general, in the Farm Bill, we want to make sure that we remove any barriers like this, either in conservation or farm programs. Remember, right now, the definition of a farm is you produce or would normally produce over $1,000 in gross sales. So it's not a hard standard to meet. But you know, one of the things that's also true, and we'd be looking at possibly minimum payments, is it's very difficult, you know, if you don't get very much, to actually get into the programs that helps you protect your land. And then finally, I want to mention disaster protection in regard to heirs property. If you don't have Schedule F or Schedule C plus documentation that you're entitled to the land, you know, you're not going to be able to get a disaster aid. So suppose there's another hurricane or other type of disaster, what will happen is you'll be ineligible. But that's also true with respect to housing. It's also true with respect to being able to secure property and casualty insurance and flood insurance, because most insurers want to know that there's an insurable interest. And then also you can't get into programs that for housing to improve energy efficiency or to make accessibility changes to your land. And we had started working with Representative Marsha Fudge, who is now going to be going over as Secretary of Housing and Urban Development, and will be following up. And if heirs property and state property laws are confusing, the intersection between state insurance laws and federal insurance programs is exceedingly complex. So I just put that out there to mention that, you know, like, you know, right now I'm dealing with 2 estates in my family and we can't get insurance on the property my cousin left behind because it doesn't have clear ownership, and it's taken over 2 years to get the court to the place of getting an executor appointed, even with a will. So remember that. And let's go to the next slide. One other thing that we want to mention is some people mentioned farm managers, and I know our colleagues, and I think especially Mark Thomas said this, you do not have to pay to get into USDA services. But we've seen a new trend. We've seen it with Latino farmers in Florida, that somebody will come to you and say, here, just sign this power of attorney and I'll get you into USDA programs. But what they do on the other end is they'll get you into a program, but then they take a cut of it between 10 and up to 40% on the back end. And, you know, we expect that if more money gets into forestry and other places, you're going to see people popping up, you know, but if you take a loan out and you have to give 20% of that loan to somebody, you're not going to be able to pay it back. So it's, again, make sure you're checking your documents. And then also protect your title. There's debt forgiveness in numerous bills. Reverend Raphael Warnock, Senator Raphael Warnock, has introduced a bill today on debt relief for BIPOC farmers, and Senator Cory Booker has reintroduced Black Farmer Justice Act, which also has debt forgiveness also for Pigford claimants. But when you do that, do the rest of the homework and make sure that when you pay off or have a debt resolved, that you get that title cleared. And then finally, it's just that there's no free money. And you know, really on the climate things, and Puneet, I really hope that there are going to be kind of continuations because we are going to be charging probably towards some sorts of payments for ecological services. And that Climate 21 memo kind of lays out that right now there is authority for Secretary, this is my very last point, for Secretary incoming Secretary Vilsack to be able to open up the Commodity Credit Corporation for payments. And there's dangers and opportunities, and I think there's room for equity provisions around them. But then also we've seen, and you know, I worked through the whole 1987 Farm Credit Farm Credit Bill and all the foreclosures. And when we see changes in land values, it could make credit unaffordable for families. So let's look at the opportunities and the risks together. And I thank all of my colleagues, and let's stop it there. And thanks so much.
Okay, that's great, Laurette. Just two last points. One of the things that, as you saw from Laurette's presentation, there's this critical need to get better data and analyze that data so we can make law and policy in a smart way. One of the things we just talked about is data on heirs property. We don't even have good data on the number of acres that African Americans own of farmland. People keep using the USDA census, but the census captures land that owners and operators of farmland or ranch land own. Many African Americans don't own a farm operation, but own the land. And so we need to get a better idea, because if you just use the USDA data, as I've seen in a couple of presentations today, it doesn't capture, if the data is being collected appropriately, the overall amount of agricultural land ownership. So that leads to, you know, claims that the land base has declined by 85 to 90%. I think the better answer is we don't know, because so many African Americans own land but don't have a farm operation. So I think this is another data point we need. And then I'd be remiss there's some people, Mavis Gregg is one, is by the end of this year, there's going to be a book by the American Bar Association on heirs property and the Uniform Partition of Heirs Property Act. I'm one of the co-editors, but we got a great set of authors, including Mavis. So I should get that point out. Okay. Puneet, turn it over to you. I think you need to unmute yourself.
Yep, I did.
Go
So
on.
we have some questions here, but not a lot. For example, Veronica McClellan is asking, are the panelists aware of any heirs property attorney work groups that are tackling these issues? And Veronica herself is the attorney. I know her very well. So I don't know who is the right person to answer that question.
I think that there need to be more. I know Land Loss Prevention Project and others, you know, have at some points have worked on networks of attorneys, but we're missing networks of attorneys. And then the other thing is that, especially when outside investment starts coming in, sometimes the real estate attorneys in your area may be conflicted because they represent somebody who wants to buy your land. So it's really important. And I think that's where we're also hearing a lot about somehow increasing the funding available for legal services. So I think that's something we have to work together on. And, you know, I'll leave it to my legal colleagues to figure out how.
Yeah, I think, you know, I've been in this similar discussion for 20 years. And the bottom line is, if you have the various nonprofits organizations, people think, well, why don't they just organize, you know, a referral network? Well, that's money out of their pocket, right? So I think there needs to be some support, whether it's from foundations or the state or federal governments, to help these organizations doing great work develop such a referral network, because it's really mostly absent. And we've been talking about it for 25 years. And folks have good intentions, but they have limited time and they don't have the resources to make that happen.
Yep.
Yeah, and I'd also note that they did provide authority in the last Farm Bill also for state mediation programs to provide services to heirs property owners, which is an important forward motion.
Okay, I think
So that's a possible source.
overall seems to me that at least that awareness is coming in, and all the work that we are putting definitely people know about at the state level with thanks to all the acts that have been passed, and also news is in the federal government, and definitely we should see some big action, especially moving on yes property issues and sustainable forestry, and in that sense sustainable agriculture, because there is also a lot of scope there. And it is my understanding that a lot of African American landowners, they are very interested in organic farming. So I think those things are important, and forestry is the topic of this workshop, but there's a lot of also opportunity in agriculture sector, especially on minority issues and so on and so forth. And off lately, I am getting some phone calls. Well, I don't have any phone anymore, usually cut it down because of budget cut, but yeah, on my cell phone, a lot of farmers getting into urban forestry and urban agriculture. So that is a new trend which is catching up. I'm pretty sure some action will be taken on those lines very soon. Okay, so I think last 1 minute for any last question for this great panel.
Puneet, earlier somebody asked about, are there any other southern states that are considering the UPHPA? So I saw that specifically. We do have a bill introduced in Kentucky this year, and there's interest in Louisiana and North Carolina, I know. So Mavis is part of a coalition that's pretty robust in North Carolina. Looking at maybe a possible, trying to get an introduction in 2022 perhaps. In Louisiana, Louisiana Appleseed has decided to champion trying to get the UPHPA introduced in Louisiana. And we have potential interest from the Louisiana Association of Realtors. They're considering whether to endorse, and there's discussions with the Louisiana Farm Bureau. The person there used to work at the Mississippi Farm Bureau, and it was the Mississippi Farm Bureau that championed the UPHPA in Mississippi last year that helped us get it enacted into law. So, we're trying to use every pressure point and leverage that we have, but we'll see.
Okay, thanks, Thomas. That was helpful. Yeah, I think all the states have all these things. It's amazing. It's very helpful for landowners for sure. So I think I will take this last question for today, and that is from Jasmine Story. Are there any programs that create a hub of experts to support landowners? Case studies. And that's a good point. Never came into my mind, because I'm not aware of any hub of experts where landowners can go and basically get help in whatever issue they're interested in. I don't know anybody of you, Eloris, might be something, because you have been in federal government and now you are managing all these research grants.
I'm sorry, what was that?
The question is that, are there any programs that create a hub for experts to support landowners? Some case studies or something on those lines? No, right?
Not.
Emma, do you know?
We kind of,
Go ahead,
we
Loretta.
kind of have informal, oh, sorry, Alaris. We have kind of informal groups that are working on policy, where we get together with the people in Washington that are working on it, and we're we're starting a conversation within the Rural Coalition right now on the climate and others, and then working with external groups, because we try and bring in, we hear from farmers every single day of the week, and you learn through all the different problems that they have what we need to do. And Mark Thomas, I'm looking at you, I really want to have a follow-up conversation. And the other thing is, we learn a lot from our partnerships with the USDA agency, because then we try and figure out, okay, once you implement something, you don't want to write something just out of your head. Some of the best people are the ones that are inside USDA. So, we do that, but we're always interested in widening, those groups, especially, to get out well thought out policies for the 2023 Farm Bill. There's a lot of money that may come into this right now, but if it's not carefully constructed, we won't get the best benefits because there's so many needs.
Yeah, I think definitely, demand is much higher than what we can supply, but it's still, if we can act efficiently in a collaborative mode, definitely we can make more impact from the same limited amount of money. There is no question on those lines.
And I think, and from some of the organizations that we know about, the Georgia Area Properties Law Center, the Center for Area Property Preservation, the Federation, what I've noticed is, 10 years ago, I would never get any communications from landowners talking about, is there something I can do to change this form of ownership? because there was little appreciation for how bad this tenancy in common under the intestacy rules was. And I've been getting a lot more communication, and I can't help any of these people because I'm, I have no bandwidth. But to me, it's a reflection that there must be this increased amount of community legal education workshops that some of these like great organizations have been doing, because it seems to have raised the awareness. So that's, it's a positive trend, but obviously that's not the level of activity that we need, or that would, so we can, advance the ball, obviously, further.
Okay, so in the interest of time, 5 p.m., let me thank everybody again for this great panel. I appreciate time of all 4 of you. And, all good things have to close. There is no question mark there. So thank you, everybody, for coming together on this one. I really appreciate your time. And I definitely want to acknowledge that we can arrange more speakers, because I know there are a lot of people who are doing incredible amount of work on yes property, sustainable forestry and whatnot. But as you know, we had only one day and we tried our best to give you a flavor of what has been achieved, what research is suggesting, and where we should go as a group. So keep all these things in mind. And, if you know anybody who needs help, now at least a few names who can help that person. So touch base with them. And if you don't know anybody, then always you can email me and I can definitely try my best to help you out. Now, before I close, I want to definitely thank Mark Thomas for all the things that he has done for this project. So Mark, thank you so much.
You're welcome, Puneet. Thank you, man. If I might put a plug in for you, you've been so gracious to put in plugs for everybody else on this conference. As you all can see, Puneet joined this fight in just 2013, coming to University of Georgia. And in 7 years, I think he's done a tremendous and amazing job for where he is. And I just want everyone to basically thank him for his passion in doing this. I mean, there's a lot of people been doing this work for a number of years. And for Puneet to come in to be where he is today, to be able to put a conference like this on, because he was adamant about it, that, when we hit COVID-19, Mark, we got to do this, Mark, we still got to put on this conference. So I just want to thank you, man, for your dedication to air property, especially here in Georgia. I mean, you've been a tremendous asset to us as well. So, man, it's been my pleasure to work with you. And for anyone that wants to reach out to me, I think my contact information is in the program booklet that Puneet has sent out. So feel free to reach out. I'm here and willing to work. Thank you.
Okay, thanks, Mark, for your kind words. Definitely my second thanks to Dr. John Shalhaus, who was my mentor and friend, and in between everything that you can think of when it comes to this project. So thanks a lot, John. I really appreciate all your timely inputs and help, right? And definitely big thanks to Noah and big thanks to Sarah, because they were also very key in putting all this research together. Otherwise, boy, peer reviewed is getting too complicated to publish. But thanks to all the great work that we were able to put together, and I'm very proud of this team and what we have produced, and hopefully have made an impact on what we have done in 3.5 years. And hopefully we will make more impact by working as a team with everybody here and also who is not here. Right, so with this, also, this is official, I cannot neglect them. Thank you so much for Southern SARE for funding opportunity, because without their help and support, and definitely a lot of flexibility, especially when the country got closed in March, otherwise this would have not been possible. And thankfully, SARE is housed in University of Georgia, Griffin campus, so they understand where we are coming from. But yeah, their flexibility was really nice, especially when we hit COVID-19 kind of situation. So thanks to Southern SARE, and thanks to everybody again. We are in touch, and I don't know what to say now. Thank you so much, and enjoy your evening, I guess.
Good job.
Bye-bye, take care. And I will share all the slides and recordings. Don't worry, just give me 1 week and you will have all the things that I have. Okay. Bye, take care. Have a nice evening.